Swayam Prabha. Digital India. Educated India.
Now we look at the second aspect or the second element of patentability, that an invention should involve an inventive step. Inventive step has been defined in section 21JA. The earlier definition was much simpler definition. It just said inventive step means something that is not obvious to a person skilled in the art. But now the inventive step definition has been amended to include two other components. Inventive step means a feature of an invention that involves technical advance as compared to the existing knowledge, or having economic significance, or both. So, technical advance is a requirement. Now, what is the technical advance that we are concerned about? The technical advance compared to existing knowledge. Now, existing knowledge can be summarized as the state of the art or the prior art. So, there has to be a technical advance when compared to the existing knowledge, or economic significance, or both, and that makes the invention not obvious to a person skilled in the art. So, the requirements of inventive step would be twofold. First, the patent applicant will have to show that there is technical advance over existing knowledge, or economic significance, or both. So, that is the first component. You either demonstrate technical advancement over the prior art, or you show economic significance, either of things, or you show both. That is the first component, and that makes the invention, the feature in an invention that makes the invention not obvious to a person skilled in the art. This was the earlier definition, that the invention is not obvious to a person skilled in the art. Now, so how different is the inventive step from the novelty requirement? The novelty requirement, we had seen, involves a comparison of a document that has been published or a use with the claim of a patent application. So, it is a comparison. If the comparison matches in all the technical features, then the invention is said to have been anticipated, provided there are no secrecy provisions and the prior art document predates the date of filing of an application with the complete specification. We saw that in the definition. The definition of new invention did not mention anything about the person skilled in the art. There was no person or the entity who would be instrumental in the analysis was not there, whereas the construction for a novelty analysis would be in from the perspective of a person skilled in the art, because all patents are addressed to a person skilled in the art. It is a hypothetical construct, but the person skilled in the art himself is not instrumental in determining novelty, because the definition of new invention simply does not mention anything about the person skilled in the art. Whereas in an inventive step analysis, the key ingredient is to see whether the invention was not obvious to a person skilled in the art. So, the person skilled in the art comes into the picture for an inventive step analysis, and the person skilled in the art is attributed various traits. For instance, a person skilled in the art is attributed to know every knowledge in that particular domain that has been published or that forms a part of the common general knowledge. He is attributed to it because he is in a hypothetical construct. The person skilled in the art is attributed, some cases have attributed a capacity of not getting bored, which means if there are thousands of documents which form the knowledge of, or the common general knowledge of a particular art, then the person skilled in the art would be attributed the knowledge of all those 1000 documents, meaning which it would be assumed that he has read all those documents. So, he has a capacity to understand things in the particular art, and that capacity is almost infinite in the sense that he will not be expected to get bored in the process of understanding the scope of the prior art. Now, what cuts the person skilled in the art and inventor who has come up with a patentable invention is that the person skilled in the art, though he had the entire knowledge pertaining to the art, he was not able to make that inventive leap or that inventive step. Now, the inventive step, there are various analysis which tells us what the inventive step is. We just understand an inventive step as a step from the prior art to the invention, which is a non-obvious step. A person in the art would not obviously take that step. It is non-obvious, which means not every person in the art who has the knowledge of the art would take that particular step. Now, there are yardsticks for determining what that step is. One yardstick, which is now a part of the definition, is technical advancement. So, the art advanced to a particular point, and the entire art, that is the field of technology, was at a particular point of development. The invention, which claims to have an inventive step or which involves an inventive step, made an advancement from that point, what is contained in the phrase technical advance as compared to the existing knowledge. So, there was a technical advancement, and that was a substantial advancement, not something which a person skilled in the art could have foreseen. So, that was a substantial advancement, and the substantial advancement is something which is not an obvious extension of what the work that is normally done, or the courts have also used the word workshop improvement or workshop variation. By workshop improvement or workshop variation, we understand the various things a person skilled in the art would do if he is encountered with a problem. So, there is a problem, and to solve the problem, you can attribute the person skilled in the art in a particular field of technology to do various courses or take recourse to various steps, and all those steps, if it results in something what could be claimed as an invention, will still not amount to have satisfied the requirement of an inventive step, because those steps the person skilled in the art would have anyway taken if he was faced with a problem. So, anything that would be done ordinarily by a person skilled in the art will not be regarded as constituting or contributing to the inventive step. So, the first step in understanding an inventive step is to determine the person skilled in the art. Who is the person skilled in the art? To whom is the invention addressed to? The person skilled in the art is actually the addressee of an invention. The invention is addressed to him. Though an invention can be read by anyone and understood by anyone, the invention is phrased in a manner in which it can be understood by a person skilled in the art. So, the person skilled in the art is a hypothetical construct which is created for an obviousness analysis, and the courts in many cases, the first step the court will do is to identify the field of technology to which, because in some inventions the inventive part or the inventive step may come from different fields of technology. So, the court would identify the field of technology and then identify who is the relevant person skilled in the art for that technology, and from that person, once they identify that person, it need not be a person. In the modern world, it could be a team of people. From the perspective of that person, the court will now try to analyze whether the invention involved an inventive step. Mosaicing, which we had said is not permissible for a novelty analysis, is allowed in determining inventive step, because the person skilled in the art is capable of reading multiple documents, taking things from multiple documents, putting them together and seeing whether particular problem can be solved. So, the approach of a person skilled in the art is, when he is faced with a problem, when he is faced with a technical problem, he would normally do everything his peer would do. If everything that his peer would do, then that would not make the invention to have an inventive step, because the problem got solved by a person skilled in the art doing what anybody else would have done if faced with that problem. So, mosaicing is allowed for determining an inventive step, whereas it is not allowed for determining a novelty step, for determining a novelty analysis, for the simple reason novelty analysis have to be a perfect match of the disclosure in the complete specification and in the prior art. It has to be a perfect match, it has to be complete, the match has to be complete, all the technical features has to be disclosed in one document, in one place. Whereas, because the inventive step involves the person skilled in the art, the person skilled in the art will be attributed the skill of combining and reading together documents. Now, there are different approaches in determining the inventive step. One is the problem and solution approach. The problem and solution approach is to look at the invention as a solution to an existing problem. There was an existing problem and that problem could not be solved by the person skilled in the art in that particular field, and the problem existed. Either it existed for a long time, or the fact that people were repeatedly trying to prove that problem and to solve that problem and they were unsuccessful. The problem, if it got addressed by an invention, then we would say that the invention solved an existing problem. So, this is called the problem solution approach. There is a problem that existed in the prior art and the documentation in the prior art shows that there is a problem and the invention actually solved that problem. So, the problem solution approach is an important tool in patent drafting, because once you envisage the invention as a solution to a particular problem, then it becomes easier to demonstrate inventive step, because the invention is now presented in the claims as a solution to an existing problem. Now, there are 3 stages in the problem solution approach. The first stage, what are we doing in a problem solution approach? In the problem solution approach, we are trying to determine whether an invention involves an inventive step. So, there is an invention which is disclosed in a patent application, which is filed along with a complete specification. So, we have a claim which discloses an invention. Now, we want to ascertain whether this claim stands clear of an inventive step analysis. So, one of the approach, and this is predominantly followed by the European Patent Office, is the problem solution approach. And in the problem solution approach, the first step would be to determine the closest prior art, because as we mentioned, if we understand the inventive step as a step taken from the prior art, which a person skilled in the art could not take, then it means the step was taken from the closest prior art. So, the closest prior art, there could be multiple prior arts in a particular domain. What was the prior art that was closest to this invention? So, the first step will be in determining the closest prior art. So, if there is a mistake or an error in identifying the closest prior art, then your problem solution approach for determining inventive step will be faulty, because you did not identify the closest prior art. So, the closest prior art will tell you whether the leap from the closest prior art, or to use the step from the closest prior art, was something which was not obvious to a person skilled in the art. So, the first step in the problem solution approach is to determine the closest prior art. Second step is to establish the objective technical problem to be solved. Now, we identify the closest prior art, and the second step is to establish the objective technical problem. Now, these are phrases which have come from the European courts. We may simply phrase it as, what was the technical problem? Because the closest prior art would have enumerated the problem, but it would not have solved it. So, first we identify the closest prior art, then we establish the objective technical problem to be solved. So, we define the problem or we identify the problem to be solved. And the third step is considering whether or not the claimed invention starting from the closest prior art and the objective technical problem would have been obvious to a skilled person. That is the obviousness analysis. So, we start from the closest prior art and keep the technical problem in mind and see whether the invention would have been obvious to a person. So, it is still an analysis of whether from the closest prior art, keeping in mind the problem to be solved, a person could have done this. Let us take the example of a paper clip. The paper clip, when it was first invented, it did the job of holding papers together without damaging them. Let us assume that the prior art before the paper clip was a wire which has to be pierced through the document, or it was some kind of a clip which had to bind the document, which could damage the document. So, the paper clip solved the problem of holding papers together without damaging them. Now, the paper clip is quite a simple invention because it is a steel wire which is bent appropriately in places to hold paper in between the wire. Now, what would be the closest prior art for a paper clip? The closest prior art could be a clip, the closest prior art could be a steel wire, it could be a thread, it could be punching machine and which could punch holes onto the document and tie it up. It could be, so of the list of prior arts that are there, the first step will be to determine the closest prior art. Let us assume it is a steel wire which can be pierced through the document and tied together. Let us assume for the sake of understanding this better. Now, once we identify a steel wire or a bit of a wire as prior art, closest prior art, and by this we understand that it is either disclosed, it is manufactured, or it is disclosed in some document. Now, we understand what is the technical problem that had to be solved, objective technical problem to be solved. The objective technical problem to be solved is managing paper or grouping paper together without damaging them. So, to holding paper together, if you stick the paper together, when you remove them apart, it damages them. If you stitch them together, it damages them. If you put a hole and tie it up with a string or with a thread, it again damages them. So, if we understand the issue of the problem to be solved by the paper clip as holding paper together without damaging them, then we will say that the technical problem or the objective technical problem to be solved is to manage papers together without damaging them. Now, we have the closest prior art, which is a steel wire, and we have the problem of managing paper together without damaging them. Now, with these two things, will it be obvious to a person to come up with a paper clip? Now, if the answer is yes, it would be obvious, then paper clip would not solve or would not involve an inventive step and it would not be granted a patent. But history tells us that there are multiple patents over paper clips over a period of time, especially from the US Patent Office, and history also tells us that paper clip was a hugely successful product which had multiple patents on over a long period of time. So, the problem the first paper clip solved was managing paper without damaging them, and if you look at the prior art, which was just a steel wire, it would have been difficult for a person at that point to envisage a steel wire in such a way that it could be used to hold paper without damaging them. So, this was the problem that was solved by the paper clip. So, the starting point of the closest prior art, we will assume that it is a steel wire, it is a plain steel wire, and the objective technical problem, which we will assume that managing paper, holding paper together without damaging them in any way, so that you could remove the papers and use them as they were in its original condition. If a person who knew the closest prior art and the technical problem could have solved it by coming up with a paper clip, by bending a steel wire in particular places to hold the paper. If the analysis would allow that to happen, then we would say that the invention would not involve an inventive step. If on the other hand, if it can be ascertained that it would not have been obvious to a person who had a steel wire and papers to manage and this problem of damaging paper, then the invention would be non-obvious, or the invention would involve an inventive step. Now, one of the things that affects an inventive step analysis is hindsight. Now, hindsight is can be demonstrated well in the case of a paper clip. Now, if you reverse engineer a paper clip, you get a steel wire. If you unbend it, you get a steel wire. So, it could be possible for people to assume that in hindsight that this is obvious, because it was just a simple piece of wire that was bent in few places. So, one of the principles is that when assessing inventive step, it is important to avoid viewing the solution with hindsight, that is an ex post facto analysis. You should not view the invention with hindsight, because in hindsight it would appear that the invention was obvious. So, the problem solution approach helps us to avoid hindsight, and that is a great way in which patents can be drafted, because in drafting, when you use the problem solution approach, you are actually eliminating the possibility of hindsight creeping in. Avoiding hindsight means that obviousness should be analyzed based on the prior art without any knowledge of the invention. So, when you look at the steel wire, you have no knowledge of the paper clip. So, that is a way in which you can eliminate hindsight. And the problem solution approach, because the problem solution approach involves looking at the problem to be solved, it helps you to avoid the hindsight issue. We just saw that one of the ways in which we can determine inventive step is by the problem and solution approach. There is another approach which has been recognized by the Indian courts. This is called the windsurfing approach. Now, this was developed in a case called Windsurfing International versus Tabor Marine. Now, in this approach, there are 4 steps which kind of overlaps with what we had seen in the problem and solution approach. The first thing would be to identify the person skilled in the art. The first step is to identify, and the person skilled in the art is a notional person, it is not a real person. First you identify the person skilled in the art, and you identify the relevant common general knowledge of that person. The common general knowledge is a term that is used to describe the knowledge that is attributable to a person skilled in the art. It need not be knowledge that is documented, it can be knowledge which is known to that person or known to the people in that field. So, the first step is to identify the person skilled in the art and to identify the relevant common general knowledge that is attributable to him. 2. Identify the inventive concept of the claim in question. What is the inventive concept in the claim? The first step was to identify the person skilled in the art and the knowledge attributable to him. Now, you come to the patent application and look at the claim and try to understand what is the inventive concept in the claim. What is it that the claim covers for which a protection is claimed, the inventive concept. The third step, identify what differences exist between the matter cited as prior art or state of the art and the inventive concept. Now, here comes in the earlier approach we saw that the closest prior art was identified, then the problem was identified. In this case, because the person skilled in the art is already identified and the knowledge is attributed to him, we look at what forms the state of the art, because state of the art is determined through the person skilled in the art. We look at what forms the state of the art, or we identify the state of the art and see the difference between the state of the art and the claimed invention or the inventive concept. So, the third step will be, now that the person skilled in the art is identified and the inventive concept has been construed or constructed, we see the difference between these two things. There is prior art and the inventive concept. In the earlier analysis, there was the closest prior art and the problem to be solved, and then you had the invention itself. So, once you do this, that is the third step, you will identify some difference between the prior art and the inventive concept. There is some difference between these two things. The fourth step and the last step will be, viewed without any knowledge of the alleged invention as claimed, which is removing hindsight, do the difference constitute steps that would be obvious to a person skilled in the art. Now, this was the last step even in the problem and solution approach, whether the step or the movement from the prior art to the invention would have been possible for a person skilled in the art. It would have been possible for the person skilled in the art, then we would say the invention is obvious. If it would not have been possible, then we would say it involves an inventive step. So, the last part of the analysis is the same, to see whether from the prior art you could reach the invention, the journey from the prior art to the invention. If the journey from the prior art to the invention is obvious, then there is no inventive step. If that journey is not obvious, a person skilled in the art would not do it, then we will say that the invention involves an inventive step. So, the windsurfer test or the windsurfing test has 4 steps, and it involves starting with identifying the person skilled in the art and the knowledge attributable to him. 2, it involves constructing the claim, identifying the inventive concept, then identifying the difference between the prior art and the inventive concept, and seeing whether it would have been obvious to a person to make that journey or to take that step. So, in essence, any inventive step analysis would involve understanding the invention per se, the inventive concept, identifying the prior art, that is the second step, and seeing whether the movement or the journey from the prior art could have been done by a person and would have been obvious to that person. So, we bring the obviousness element. If it would have been obvious, there is no inventive step. If it had not been obvious, then there would be inventive step. The date of assessment of the inventive step is from the priority date. So, if an invention has a priority date, the inventive step analysis is done from the priority date of the invention. So, all the documents that precede the priority date can be used for determining inventive step. So, we found that these 2 steps, these 2 approaches, the problem and solution approach and the windsurfing approach, tells us what are the steps that could be considered in determining inventive step. There are certain secondary indications of inventiveness. Now, the secondary indications of inventiveness are secondary factors that may indicate that the invention is inventive. Now, this is not to say that the primary factors, which the invention is not obvious to a person's skilled art, should be brushed aside, but these secondary factors have been used by the courts of law in determining inventive step. So, some of the commonly applied secondary factors include a surprising effect or result. Now, again, this is something which you will find in patent drafting. In many patents you will find that it was surprisingly found, or there was a surprising result, and then they will mention what was the surprising result or the effect. Now, this is considered as a secondary factor in determining inventiveness, because a surprising result could be something which does not happen in the normal course. So, something which happens out of the normal course could amount to a secondary factor in determining inventive step. Another secondary factor is a long felt need. The prior art had a long felt need. There was a need to have a particular invention. The prior art showed that there was a need, but the need was not addressed. So, the invention addressed that long felt need. Again, that is a secondary consideration. Overcoming the prejudices of the prior art is yet another secondary factor. The prior art was prejudiced in a particular way, and the invention thought away from the prior art. In fact, it got over the prejudices of the prior art and came up with the invention. So, that is another secondary factor. Commercial success, the fact that the invention came out into the market and it was a commercial success, could be another secondary factor or secondary indication of inventiveness. Reaction to the invention, that how the invention was perceived, could also be one of the secondary considerations. Now, reaction to the invention could include the competitor trying to license the technology from an applicant. Now, this is very similar to commercial success. There is a clear demonstration that the technology is needed and is appreciated. And so is copying. When the market copies an invention, that could also be regarded as a secondary factor for considering inventiveness.